In addition to Mr. Kruller, who admits that this scaffold was defective, we will also present to you the testimony of an expert witness. Her name is Kathleen Hopkins. She's a nurse, but she is also a certified site safety inspector. She has been inspecting buildings in the early part of her career for major contractors and major insurance companies. She's worked for Tishman Construction, she has worked for AIG, and she's worked for other major companies, going to the sites and inspecting them. And we have sent her all of what we call the discovery, and you've heard from the judge in his preliminary charge what discovery is. We have sent her all of the discovery in this case. And we asked her to review all of the discovery and to come before you and to opine, to give you her opinion about what transpired here. And ladies and gentlemen, she will come before you today, and she will opine that this was a defective and dangerous scaffold, that in addition, this scaffold did not comply with the industry practice, meaning that throughout the industry, carpenters who are putting up sheetrock are given scaffolds with all 4 rails. She will also opine that because of this defective scaffold, Mr. Kruller was not provided with a safe place to work. And that as a result of all of that, he fell and tumbled from the scaffold, and that fall was caused by a substantial factor in causing that fall was the negligence of the defendants in not having the 4 side rails. Ladies and gentlemen, there will also be the subject before you today from the defense. You will hear from them. And they will talk about Mr. Crumble's obligations in this case. And when you listen to the evidence, ladies and gentlemen, I ask, as I asked you in jury selection, to be careful about what you hear. They are going to say to you, for example, that there were certain safety meetings and Mr. Crumble knew all about putting up scaffolds himself. Well, it's undisputed, number one, that Mr. Crumble came from Poland just 4 years before his accident, and that English was clearly not his first language. They will tell you that Mr. Crumble himself should have found some side rails somewhere, that he should have searched the 20,000 feet of each of the stories, and that it was his obligation. Well, Kathleen Hopkins will tell you that that's just not what happens on a job site. Workers don't just go moseying around sites looking for pieces of scaffolds. They are supposed to be supplied with it, and if he's not putting up the sections of ceiling that he's required to put up by the end of the day, he's not invited back to work the next day. And so you will hear from the expert, Ms. Hopkins in this case. You will hear, and I ask you to pay careful attention to the admissions that Mr. Kruller will be forced to make. And ladies and gentlemen, we will then get to the phase of this case called the damages phase. And when we get to the damages phase of this case, you are going to learn about a horrific accident. Mr. Crumble migrated from Poland just 4 years before this accident. He came with his wife, who, by the way, although things are very amicable, they are currently separated, but he came with his wife and his 2 children to live the American dream. And Mr. Crumble worked hard when he got here. He worked in various industries, sometimes off the books, making his first year or two about $15,000 or so. And then you'll hear that he got a job in the construction industry, which he loved, and that he made substantial amounts of money as time went on. And ladies and gentlemen, during the course of this trial, in terms of the damages parts of this case, there's really, as we talked about in jury selection, 3 major components. The first component is really the easy component. And the easy component is he made a certain amount of money. He can no longer make that amount of money. He received certain fringe benefits. He can no longer receive those. And while there might be some dispute about what those numbers are, I don't expect a very vigorous cross of our economists. Those numbers, it's just a few $1 million. It's not complicated. The biggest parts of the damages in this case, ladies and gentlemen, are when we get to the sections of what we call conscious pain and suffering and parental care and guidance. Let me take one at a time. There will be evidence in this case with regard to Mr. Crumble's conscious pain and suffering. And the evidence in this case with regard to that will be that when he fell some 8 feet from the scaffold, he hit his head on the concrete slab. And his brother-in-law, who had been working nearby, was the first to rush over to him. And while Mr. Crumble lay on the ground, his brother-in-law holding his hand, Mr. Crumble, asked his brother-in-law what happened, and he repeated that several times while he was still conscious. But what Mr. Crumble didn't know at that time was that due to the shearing forces of the veins which are inside of his brain, that he was bleeding in his brain. And you will hear from a medical examiner in this case, not today, but you will hear later on during the trial from a medical examiner. And the medical examiner will explain to you that our brains, which are contained within our skulls, are wrapped by what we call a dura lining. And that when there is a massive impact to your brain, and there are shearing forces that shear the veins inside of your brain, below the dura and between the brain and the skull, there becomes bleeding. And unlike when you get hurt, let's say, for example, if you hurt your leg and you see it swell up with a big hematoma, a big black and blue mark, we've all seen that before, well, your skin in your leg can expand. And so you're not going to die from that kind of an injury. But when it's your brain, there's nowhere for it to expand. And so they rushed him to Lenox Hill Hospital. They did an emergency craniotomy where they cut open his skull to allow the pressure of the bleeding some room. But it was too late. And he was on life support. And within 48 hours, this healthy, young, vibrant man died. And he left behind, ladies and gentlemen, 2 children. And while you'll hear from the medical examiner, and you will be asked at the end of this case to determine the amount of conscious pain and suffering and the value of that, you're also going to be asked to evaluate the subject matter of parental care and guidance. And Mr. Miller, my colleague, will get more into that during the summation. But you will hear evidence from these 2 young boys who will be brave enough to testify about the kinds of things that they did with their father and the kind of guidance that their father gave to them. And at the end of this case, my colleague, Mr. Miller, will get up here and ask that you return a verdict in favor of the estate of Mr. Crumble, consistent with the evidence. Thank you very much.
Can I get my checkbook out now?
Yes. Okay, from the defense side. May it please the court, ladies and gentlemen, the jury, Your Honor. As you already know, ladies and gentlemen, we talked about this during the course of jury selection. I represent the owner and the general contractor in this case. And you've already heard a little bit about who they are in the opening statement of the plaintiff's attorney. You heard that they were some of the biggest and largest contractor and owner of property in the city of New York. Well, let me tell you something, ladies and gentlemen. They are, and we're proud of it. Some of the buildings that you go into on a regular basis were built by these dedicated men and women. And they are proud of the construction and the projects that they have brought to this city. And you know something, ladies and gentlemen? We take the allegations that you just heard, we take those allegations very seriously. And we are here because we believe that the evidence in this case will show, not that there was any liability by Crispy or Duncan, but rather, ladies and gentlemen, there was one person responsible for this accident. There was, ladies and gentlemen, the evidence will show, one person who could have prevented this accident. And there was one, and only one, sole proximate cause of this accident. And that was Victor Crumble. And you promised me, you all raised your arm and took an oath, and you promised me that you will evaluate this case calmly and coolly and without emotion. And when you do that, you will find the evidence will show that Mr. Crumble bears 100% of the responsibility for this tragedy. Ladies and gentlemen, construction sites are dangerous places. We all know that. And we do the best we can to keep them as safe as possible. And we can educate workers. We can tell them what to do and what not to do. We can give them handouts and paper that they must read and sign. We can do lots of things. But one thing we can't do is we can't force somebody to do something. We can't impart to each worker common sense. And when you listen to the evidence in this case, you will be asked by me to please focus on that issue of common sense. And what do I mean by that? What my adversary didn't tell you in his opening statement were that every single day on this project, for the 3 weeks that this man, Mr. Crumble, worked on this project, we had toolbox meetings. And what's a toolbox meeting? You'll hear all about it from the site safety foreman, Mr. Crawler, and you'll hear all about it from the expert, Ms. Hopkins. At those toolbox meetings, on each and every one of those occasions, Mr. Crumble was told that for the work he was doing above his head on the Baker scaffold, that scaffold required 4 railings. He was told this each and every single day. You heard something earlier that maybe he didn't speak English well and that maybe that's the excuse, he didn't understand. Well, guess what, ladies and gentlemen? You're going to hear evidence from Mr. Crowler later that it wasn't just things that were said, that putting these railings on the scaffolds was demonstrated to Mr. Crumble. And how do we know that he understood? Well, the evidence will show that on at least 3 or 4 prior occasions, he used scaffold just like this with all 4 sides. So clearly, he knew that the scaffold required 4 railings. These dangers were explained to him. And don't take my word for it, because there will be evidence in this case. Mr. Crowler will testify about it, but in addition to that, we will produce and put in front of you the meeting minutes, and we will put in front of you during the course of this trial the sign-in sheets from every one of these meetings. And you will see that both Crumble and Glaze signed in on each and every occasion. Now, let's go a step further. In addition to him being told and shown, the evidence will show in this case, ladies and gentlemen, that the 2 side railings that belonged with this scaffold were directly above him on the next floor. Easy to find, not hidden, but directly above him on the next floor. And what's the normal and logical response for a construction worker? What does common sense tell you? If you're looking at a scaffold that's 8 feet up in the air and it's only got rails on 2 sides, well, you better go find the other 2 rails. Isn't that the normal and logical response that would be expected of a construction worker? And the evidence will show, ladies and gentlemen, that if he had taken just a few minutes to look around, they were there to be found. And clearly, he didn't bother to do that. In addition, ladies and gentlemen, the evidence in this case will show that this scaffold, without the two railings, that is as open and obvious a danger as you can ever imagine. And you don't need experts to tell you that. All you have to do is look at it. So here's Mr. Crumble. The evidence will show that he's on top of the scaffold for 3 or 4 days doing work, and on each and every one of those occasions, it's got 4 rails. And he's working all day, and they've got 4 rails. Well, what changed on this particular day? What changed was he didn't put the other 2 rails on that were right above him on the next floor. He could have appreciated easily by just using his own senses that this was a dangerous condition. And he, ladies and gentlemen, the evidence will show, was the sole proximate cause of his own accident by not going and getting the other rails. It really is very simple. He is the one, very important, he is the one who set this scaffold up. That's an undisputed fact. He put it into place, and he knew enough to lock the wheels. He locked the wheels of the scaffold after he put it in place. So it's not a worker who doesn't understand how these things move or how these things are to be built. He clearly understood it. So he was told, they were available, and he should have appreciated it. He did none of those things. And I submit to you, ladies and gentlemen, that had he done any of them, we wouldn't be here today. You've heard a little bit about the damages in this case, and I don't believe that you will ever reach that. But I do ask you, when you hear the testimony, to be critical of it and to think about what his background really was and how much money he really made or didn't make, and to think about the testimony of Mr. Glaze, the brother-in-law, whose 2 nephews are now left without a father, and whether that what happened conversation actually ever did take place. And I ask you, ladies and gentlemen, throughout the course of this case, to keep an open mind, to listen to the evidence, but to remember that the only reason this scaffold was inadequate was because Mr. Crumble didn't put the 2 side rails onto it. Thank you for your time. I appreciate it. And I'm sorry we went a little late, ladies and gentlemen, but we will reconvene at the appropriate time in 1 hour from now. Thank you very much.
That concludes this segment of the program.